Hello, and welcome back to Maine Justice. It is Tuesday morning, June 30th. I am Andrew Weissman, and I am not here with Mary McCord, my co-host. And I know for many of our loyal listeners, you must be thinking, this is the first in 3 years of doing this podcast that it has not been Mary and me. Mary has a personal emergency, so we're going to today just do a quick top line given the Supreme Court news yesterday and today. And then we will be back once Mary's in pocket, either tomorrow or later this week, or for our regular show, certainly next week, to cover more about the Supreme Court, as well as we will cover some other things that Mary and I had been talking about this weekend. But with that, let's start with yesterday's decisions. Then I'll come to what happened today. I think many people listening to this know that yesterday was a big deal in the Supreme Court. There was lots of so-called good news. There were cases that came out in ways that I think many people, certainly Mary and I, approve of. First and foremost, the court decided not to hear the E. Jean Carroll case, the first of the E. Jean Carroll cases to seek Supreme Court review, and that is the determination by a jury that she was sexually assaulted and also defamed and awarded her $5 million. And so that is now a final decision. Second, the court ruled that the Mississippi law with respect to mail-in voting was valid. That is a 5-4 decision, so very, very close. And so that is one very much to keep an eye on if the court composition to change. There was an important Fourth Amendment decision that is dear to my heart since I teach the Fourth Amendment. And there's a decision that seemingly is good with respect to the Federal Reserve, saying that with respect to the Trump administration trying to fire Lisa Cook, a member of the Federal Reserve, that it requires the Trump administration to show cause. In other words, it can't be for no reason at all. But that is maybe a really good segue to what is, I think, the most important decision in terms of its long-lasting consequences in terms of the structure of our government. The mail-in voting decision is obviously extremely important in terms of our voting rights, but the court issued a separate decision with respect to the power of the Trump administration to fire a member of the FTC, the Federal Trade Commission, and said that the executive branch does not need to have cause, that they can just fire away for any and all reason or no reason. And what's so interesting about this decision is the language used by the Chief Justice Roberts, who wrote the case. The case came down 6-3. I'm sure many of you are aware of it. And this was saying that with respect to the FTC, that again, the Trump administration can just fire people because of this idea of the unitary executive. Many people listening to this are going to be saying, wait a second, I thought you just told me that with respect to the Federal Reserve, that they do need to show cause. And that decision was 5-4 that you needed to show cause. And what happened is, just bear with me on the nerdiness, is that for the 6-3 decision with respect to the FTC, that was under pure ideological lines that it was decided, with the Chief Justice writing for the majority and the 3 so-called liberal justices in the dissent. And more on that later, because the Sotomayor dissent was read from the bench and was quite vociferous. And apparently reports were very emotional in the courtroom as she was reading it. That was 6-3, but the decision with respect to the Federal Reserve was 5-4. And what happened there was that the Chief Justice switched from writing for the majority of the 6-3 to writing for the majority in the Federal Reserve case 5-4. And he was joined by Brett Kavanaugh. So you have the 3 liberal justices and the Chief Justice and Brett Kavanaugh. And the reasoning basically is, I mean, they don't quite come out and say this, but it's the Federal Reserve, and the economy would go to hell in a handbasket if we actually said that Congress doesn't have the power to have these apolitical, bipartisan agencies. And so we're going to treat the Federal Reserve differently. To her credit, Amy Coney Barrett, who was in the majority in the FTC case, but then into the dissent in the Federal Reserve case, says you're being completely inconsistent in terms of your reasoning. In other words, I disagree with her, but she is being consistent and says, what in God's green earth? Because this is one where if you are right with respect to the FTC, then you would think that applies to the Federal Reserve. If you're wrong with respect to the FTC, it should apply to all agencies. There's no really good reason. And it sort of shows the paucity of reasoning. I wanted to just make three quick points. I know lots of people have been talking about the FTC case, which is named after Rebecca Slaughter, who is the plaintiff who brought the case. By the way, I was on air with her yesterday with Nicole Wallace. And for anyone who can get access to that, I really think it's wonderful to listen to. Ms. Slaughter was terrific and also answered so well questions about, well, what can we do now? I'm not going to give a spoiler alert, but I highly, highly recommend her answer because she's not giving up and she had very good ideas about how to move forward given this decision. But here are some quick comments I have about the Slaughter case. And maybe I'll start with the big picture. This is a decision that has to be read along with the Chief Justice's decision in the Trump criminal immunity case, because the vision of the Chief Justice of the power of the executive is larded through both the Trump criminal immunity decision and this decision, talking about the necessity of a strong, vigorous, and a unique word this time, secretive executive. I was struck by that word being used. And that was the language about vigor and the executive having this enormous power was also throughout the Trump criminal immunity case, and it is replete here. And it's so jarring given what we are living through with the Trump 2.0 presidency that you really feel, at least I do, that the Chief Justice is very much the leading henchman for the president, this particular president of the United States, but with ramifications for all future presidents except those who are going to self-restrain. And it's remarkable the positive reasoning, which is that the founders, having lived through a king, essentially wanted to recreate a king because only somebody with that amount of power can get things done. I mean, that is the gist of the Chief Justice's reasoning here. And it is so striking when you compare it to a different Justice Jackson, not Ketanji Jackson, who I will talk about in a moment, but Robert Jackson, who Mary and I talk about a lot, because Robert Jackson wrote the famous Youngstown Concurrence shortly after he returned from being the lead Nuremberg prosecutor. And he came back to this country having seen what happens with a strong executive, using the example of Germany, but to be fair, also other countries, seeing the harm of a strong executive. My second point about the use of history by the Chief Justice, where he goes back to the founders, it is, I think, a sleight of hand. There is nothing that I read from the Chief Justice that deals with the issue of whether Congress has the power to create an agency where they require for cause removals. In other words, the Chief Justice talks a lot about the different founders and how they viewed the necessity of having a strong executive, but he doesn't tie it directly to the issue before him, which is whether the Congress can create a position and create an agency that they think needs to be bipartisan and have expertise and shouldn't change every 4 years at the whim of the president. And they're not saying that the president has no power. This is not a binary, the president has power, the president has no power. All that is at issue here is that before you fire somebody, the president has to have a reason, a cause. And what is missing from the Chief Justice's analysis of history is that. Where is it that they said that even that even just that minimal showing of a reason was something that the founders said, no, 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 we don't want that, even that. And I feel like that is such a deep flaw in at least my initial reading of this case. Finally, and this is very much in the weeds, which is I'm going to turn to Ketanji Brown Jackson, a different Justice Jackson. It is not that long ago in the tariff decision where Justice Ketanji Brown Jackson was alone in an opinion saying that the methodology that the court should use includes looking at legislative history, looking at what people said at the time. And everyone else is like, who's in the conservative group of justices say, no, 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 we don't do that anymore. We don't look at legislative history. We look at the words of the text, and that's it. And maybe some context, but we do not look at legislative history. Well, let's take a look at what happened in this case where it was 6-3, where it's all legislative history. It is all about the founders and what they were thinking. And many people have said that the Chief Justice just cherry picks that history to find different snippets. And all of the criticism that the conservative justices have of looking at legislative history because they say it's very imprecise. By the way, I disagree with that. You can see here. So it is wrong, I think, both historically, it's wrong in terms of what our country needs, but it's also so wrong in terms of methodology. So you have these very, very inconsistent takes by the Chief Justice here in ways that are incredibly pernicious to our functioning government, taking so much power away from Congress and giving it to the executive at a time in our history where, Lord knows, we really do not need a stronger executive. And we're seeing that day in and day out that we do not have functioning checks and balances. So there's a lot of reasons why you're hearing in my voice this sense of a cri de coeur that there's a real problem here. So now to today's decisions. There were three main decisions today. One will take up all of the oxygen in the room. We will discuss all three at a later date. I'm going to spend most of my time giving you a quick take on my view of one of them. So there was a transgender decision, there was a campaign finance decision, and there was the birthright citizenship decision. Let me talk about the last one. The 14th Amendment provides all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Well, today, the Supreme Court said that that provision in the 14th Amendment meant what it said and said what it meant. But that is not the main news here because the decision was 5-4. 5-4. We are one justice away from having birthright citizenship snatched from all of us. And there's been some confusion about whether this is a 6-3 or 5-4 decision. So let me clarify because people are getting this wrong. It is a 5-4 decision on the constitutional issue about whether birthright citizenship in the Constitution is there and would not permit the Trump executive order. It's 5-4. People are confused because Justice Kavanaugh does have an issue with a statutory issue. He says that Congress passed a statute that is in conflict with the Trump executive order. So what he says is, by the way, Congress could change the statute and it would pass constitutional muster. In other words, he agrees with the dissents here. So there are four justices, including Justice Kavanaugh, who say that what the Trump executive order is trying to do is constitutional. And that is why I say we are one vote away, not two votes away, one vote away. And so I want to make sure people understand that because you may be reading material where people say it's a 6-3 decision. And to give you a sense of how far we have come in terms of thinking about this issue, a year ago, when this issue was first being litigated at the district court level, before it wended its way all the way up to the Supreme Court, the first judge to confront this was a judge appointed by Ronald Reagan. And this is what he had to say, quote, "I've been on the bench for over 4 decades. I can't remember another case where the question presented was as clear as this one. This is a blatantly unconstitutional order. Where were the lawyers when this decision was being made?" Unquote. That tells you how much norms and how we think about the law and what we are entitled to have changed under Trump 2.0. This decision is one where the Chief Justice wrote it. Amy Coney Barrett joined in with the 3 so-called liberal justices, but the 4 conservative justices wrote various dissenting positions on the constitutional issue here. Let me just take a moment, though, to read from a separate concurrence by Justice Ketanji Brown Jackson that I found very moving when she talked about the scope of the 14th Amendment. As you may all remember, the court was dealing with a variety of issues, but one was the 19th century decision in Dred Scott, where the court had said that slaves were not citizens. And that was put to one side by the 14th Amendment, finding that that was an outrageous position and that citizenship ran through the soil and not through the bloodline. That it comes up repeatedly in the majority opinion. And Ketanji Brown Jackson takes some time to talk about the purpose of the 14th Amendment, how it is not at all race neutral, how the purpose of the 14th Amendment was to be remedial, and to be remedial, you had to be able to consider race. And she concluded the following: "The distortion of historical facts, retellings that reimagine and repurpose past events to lend credence to misbegotten aims may be an even greater threat." She's talking about the threat to America. "Yet here we are, the government, the principal dissent, and a handful of revisionist commentators now vigorously promote an interpretation of the Citizenship Clause that diverges sharply not only from what the text says, but also from the historical record as interpreted by the keepers of the call of remembrance, trained historians. Freed Blacks fought for the shared humanity of all people, and the great emancipator eventually foresaw that the only path forward that could prevent a return in any form to slavery and race-based subordination was to link the fates of all. Of course, the ultimate irony," I'm continuing quoting from Justice Ketanji Brown Jackson, "the ultimate irony is that for all the talk of the detestable Dred Scott decision, the government and the principal dissent propose a return to its core tenet. Their bottom line is that for certain people, being born on American soil will not suffice to confer citizenship. It is that odious conclusion that the Citizenship Clause plainly rejects, as the court explains. I add only that the 14th Amendment's universalist aims should forever be the death knell for this kind of claim, one that seeks to make bloodline the marker of birthright. The America that was reborn from the rubble of the Civil War simply does not countenance that inequitable result. Thankfully, a majority of the court remembered this today and has dutifully preserved the most basic, animating principle of our nation's founding, that all human beings are created equal, once more." Those words were in support of a 5-4 Supreme Court decision. If you don't think that the Supreme Court and the rule of law is at stake in this upcoming election and elections to come, all you need to do is read the majority and dissenting decisions in the birthright citizenship case to understand what is at stake. So with that, we will be back with Mary shortly. Thank you so much for listening. Please remember that you can subscribe to MS Now Premium on Apple Podcasts to get this show and other MS Now originals ad-free. You'll also get subscriber-only bonus content. And a reminder, we are available now on YouTube, so you can head to ms.now/mainjustice to listen. This podcast is produced by the wonderful Vicky Vergolina. Nicholas Vinuela Yodar is our associate producer, and Cassidy Corey is our intern. The audio engineers for this episode are Bob Mallory and Hazik bin Ahmad Fared. Katie Lau is the senior manager of audio production, and Aisha Turner is the executive producer for MS Now Audio. Search for Maine Justice wherever you get your podcasts and follow the series.